Good morning. This is the Senate Judiciary Committee meeting on June 4th, 2020. And today we are taking up H.580, an act relating to establishing a classification system for criminal offenses. Senator Sears, our chair, will be joining us at some point on the telephone from somewhere on the road when he can get near Wi-Fi. And Senator White will be joining us at about 10:30. So I guess we're ready to start. So the first person testifying on this bill is Representative Martin Lalonde, who is the sponsor of the bill, and it's come over to us from the House. So Martin, why don't you go ahead and tell us some information, and then we have some questions for you.
Sure. Yes, Martin Lalonde, representative from South Burlington. To talk about H.580, I can give you a little background, or we can go right to questions, whatever your preference is, Senator Nitka.
We know some of the background, but I guess if you would give some of it for anybody that might be listening, that would be great.
Okay, sure. So this is a very long-term, or has been so far, a very long-term project, starting in 2013 when the legislature passed Act 61, which created the Criminal Code Reclassification Working Group to review all of Vermont's criminal penalties, as well as to look at other states' sentencing structures. And the working group was tasked with recommending a sentencing structure that allows for sentencing that is consistent with the gravity of the offense, the culpability of the offender. In 2015, that working group, which included at least one individual who's going to be testifying today, Judge Treadwell, recommended a 5-tier classification system for felonies and misdemeanors, with a maximum term of imprisonment and a maximum fine for each tier. So after some initial work, it was determined that implementing that recommendation would require a substantial amount of analysis by all the stakeholders in the criminal justice area. So actually over a summer, I think, maybe Eric remembers this, it was 2 or 3 summers ago, Eric Fitzpatrick of the Legislative Council, and I were trying to figure out how to propose a bill that would implement the recommendations of that working group. And it became pretty clear that it was a very large task, a complex task, and a very big lift. The approach we took was to seek a further working group with some of the same stakeholders to make recommendations as far as how to implement that 5-tier classification system. And what ended up from that, and this is really was from the Senate's good idea, was to send this over to really reform, bring out of retirement, I'll say, the Sentencing Commission, which was already on the books, but was essentially moribund. So with Act 142 in 2018, the task of implementing this reclassification system was given to the Sentencing Commission. And the Sentencing Commission has been working over the last couple of years on that task. So the initial recommendations came out, was it last, it's all blur now, was it, I think last November, if I'm remembering right. But the purpose that the Sentencing Commission's work, that guided the Commission's work, was essentially to establish a rational criminal code using Vermont's current code as a starting point. So the idea is that a clear or more rational code would provide consistent interpretations of our criminal offenses, would give better notice to citizens and to police as to what conduct is prohibited, and importantly, greater proportionality between offenses and punishment, and greater uniformity as far as sentencing practices throughout Vermont. And the end goal really is to have a more consistent and understandable criminal code to improve our criminal justice system. We had a lot of testimony regarding the the benefits of having this criminal code. And I'm sure you'll hear from the Defender General's office today from Marshal Paul, who offered some very compelling testimony to our committee on the benefits of having the criminal code. And I'll let him, rather than my repeating what he had told us, I'll certainly defer to him. But he had very compelling testimony on the benefits of the code. So where we ended up and what we really decided to do, the commission, as well as just in my conversations and strategizing with legislative counsel, there was an approach of doing this thing wholesale, just trying to redo the whole criminal code at once. And in fact, as I mentioned before, Eric Fitzpatrick and I sat down and started working and looking at that. Well, mainly legislative counsel with me in the loop. And that just really was a very big lift. So we looked at another possibility, another approach, and I wouldn't call it's not piecemeal approach, but it's a consecutive approach. It's what we've decided to propose, and actually, really, this was something that came then from the Sentencing Commission as well, in discussions in the Sentencing Commission, was to set up the basic structure, actually put that into law, the basic structure of the tiered system of felony A through E and misdemeanor A through E and the associated penalties, and then start going through the various offenses in Vermont law, criminal offenses, and by category. For instance, this bill, H.580, addresses property crimes. The commission has already made a recommendation regarding sex crimes. They are working on the other categories or classifications of crimes, the drug crimes, for instance. So any event, the idea was to set up the structure and then go through each of these classes of offenses and place each offense that we have in the criminal code into their appropriate category. And what I found to really be a benefit to this whole process, to this project, is that it is causing us to do a systematic and thorough review of all of our criminal offenses and the associated penalties. And it's giving us an opportunity to adjust what those penalties are to reflect the latest understanding and research and such about what kind of criminal penalties work. What that is leading to is a narrowing, and at least so far, in the property crimes, a narrowing or reducing of some of the maximum penalties to really reflect that putting somebody in prison for 10 years for a property crime might not be the best idea. It also, and this is something I'm sure that the witnesses will get into more, part of what has guided the process of trying to determine where an offense should go is looking at what's called the going rate. In other words, what is the average sentence that individuals are getting for different offenses? And we've been working with the criminal research group to have that kind of information to inform the process. So even though we're narrowing those sentencing ranges, we're being guided by really what the sentences are that courts are providing right now. So the idea, again, with 580 is to set that basic structure and to show how it's going to work. Really, is we've done the property crimes, although the way that the property crimes are set up has a separate tiered system as well, but that really came from, again, a close look at how we should deal with property crimes. I won't get into that particular detail right now. And the commission is continuing its work in making the recommendations. There's a subcommittee headed by Judge Treadwell making the recommendations as far as where the other offenses should be categorized, how they should be categorized. And hopefully we'll be able to take that up in the next biennium. But this essentially gives us some, it gives us some momentum. It shows the Sentencing Commission that its good work is in fact leading to some results. It essentially puts a stake in the ground to, that we are going to finally finish this after, my understanding, decades of considering how to modernize and rationalize our criminal code. So happy to take questions.
Very good, thank you. And you hope to finish it by when? Just as,
So there's a there's a provision in H.580 that has this going into effect. I believe it is July of 2022. It's the end of the next biennium. And for whatever offenses that have not been specifically categorized, it would automatically place offenses into a particular category, and that's in the bill. It's called the transition period, but it's really something that would happen if a particular offense was not specifically categorized.
okay,
But
thank you.
it gives a sufficient time. I mean, I think it's important to get this started. Again, it's a complex project. It's a big lift, and the idea is to lift these discrete components as we get the recommendations from the Sentencing Commission.
Okay, thank you, Martin. So I know when we were going over the bill in our committee, there were a number of questions, and let's see, would you want to hear from other persons, or do you want to do some questioning now of Martin? What would be the committee's preference?
I see Dick has joined us.
Aha, great. Hi, Dick. Good morning.
Yeah.
Good morning,
Hi.
Senator Sears.
Hi, how are you? Good
So-
morning. Sorry I missed your opening remarks. I
So
think
I got
you-
everybody sold on the whole idea from my opening remarks, Senator Sears. So
Well, I'm glad to hear that.
So Senator,
However, I do think there's a couple of questions, but go ahead. Ms.
so Senator
Bauer.
Sears, do you want to hear from any of the other witnesses before we do questions, or what would
No,
be?
I'd like to question Representative Lamont. I would like to see us question Representative Lamont if we have questions about the bill. He may need to go zooming elsewhere today.
Okay,
I
very,
have to zoom.
He
at
does
that
have an
11
impressive, as I look at him, he does have an impressive bookcase behind him, and I see he's shaved.
yes. So I guess, why don't you take over, Senator Sears? And I know Senator Baruth has a question right out of the
All
gate.
right, all right, Senator Baruth.
Thanks for joining us, Representative Lalonde. I find myself very sympathetic with this whole project. I think it's a great aspirational goal to put everything in rational terms and in terms of equality around the state, because that's a perennial problem. My question goes back to the approach, wholesale approach versus you called it consecutive rather than piecemeal. And I can see why you might, go back and forth between those, because it seems logical to me that it might take another, not 2 years, but another 5 years before this was all completely fitted together. And as I understand it, the approach now is to put in statute the categories and the ticking clock that all offenses after a certain period of time will be fitted into those categories. But I think that's where my hesitations come in, because just to give an example on the property crimes, you said that you've offered them here as an example of how this would work, but you pointed out that in fitting the property crimes into the tiered system, you had to create an auxiliary tiered system. And that seems to me indicative of the fact that we don't know yet what will happen when we try to categorize all of the other crimes. So I suppose it's not as much a question as it is a hesitation to put in statute a series of tiers with the commitment to later make sure everything fits into those when, as with property crimes, they may spawn other shapes and necessities um, and needs as far as the statutory scheme goes. Again, not a question, but can you respond to that at all?
Sure,
That
sure.
hesitation?
Yeah, no, that makes, yeah, absolutely. So I would actually say that because, for instance, property crimes is being treated a little bit differently than we anticipate most of the other crimes being treated, that's a further reason to take that up separately as opposed to as part of a very large bill to be able to explain. I mean, it took a lot of explaining and a lot of testimony, a lot of discussion in our committee just to figure out how best to deal with this class of crimes, the property crimes. And as far as I know, and Judge Treadwell will probably be the best to talk to this because he's heading the subcommittee that's been looking at the other crimes, is I think this one is probably the one that's going to be the property crimes is going to be the most the most out of the box as far as how we're approaching it by having the separate tier as far as the value of the property. I think the others will actually be relatively straightforward, except with the exception possibly of motor vehicle or DMV related crimes. But so I think being able to have that overall structure that we're fitting this in, but then understand that there are different kind of categories of offenses like property crimes, like personal crimes, like drug crimes. It allows us to focus on the differences in those kind of categories that we want to deal with. So for instance, when we get to drug crimes, one of the issues that we're going to be looking at, or is already being looked at, is the thresholds for what makes a felony versus a misdemeanor as far as the possession amounts. And that's going to be a big lift in itself as well, to really understand that and to have that as part of this big project. That seems a little overwhelming. And I think that's, from what I understand from having talked to folks who have dealt with this over the last 2 decades, that's something that has sunk that ship before in the past, where there's been an effort to try to do this and they've tried to do it all at once and it just hasn't been able to get over the finish line.
Well, you talked also about wanting to put this piece in statute as a way of committing us to doing it. And I can't really remember another time when we've, at least in my committees, when we've talked about putting something in statute as a way of making sure we put other things in statute. So a lot of what you described is either inertia on the one hand, or people being daunted by the complexity or the politics involved with this sort of thing, because you get geographic and district-wide disparities because different people have different ideas about how severe punishment for crime should be. So it seems that all of that, complexity is being left out. And then what we're doing is, to use your phrase, we're hammering a stake into the ground to commit us, to tie us to doing it later on. And I guess my own inclination is to feel as though this, as you just said, the project might collapse later of its own weight anyway. I hope it doesn't, but if it did, then we would be put to the task of removing this from statute because it would be an empty classificatory scheme. So my question, and I know your answer because it's just 2 different approaches, but my question is why we wouldn't wait until we have the bulk of this complete. Maybe not all of it, but rather than 20% or 15%, when we have 80% and the classificatory scheme. So in other words, why we wouldn't wait until 2022 when the bulk of the work is done. So I know that's not, it's not really a question that can be answered. It's just two different philosophies, but I'd be happy to hear what you have to say on that.
Yeah, let me point out that one other, the transition provision that we have, which is in the bills, that to some extent answers that question. I mean, so most of the crimes that we're looking at, and one of the reasons I think we took up property crimes is that it was a more significant change, but most of the crimes will pretty readily fall into the category, unless we decide that we want to put them into a different category. I mean, crimes that have a 10-year felony are gonna automatically be if I'm remembering right, Class C felony. Crimes that have 25 years, that have 20 years will automatically be a Class B felony, et cetera. And most crimes are like that. Most crimes will very easily transition whether we get to them or not. There are outliers, and we've identified those. And those are some that the Sentencing Commission needs to deal with really first. Just for example, certain burglary crimes can be 15, 20, or 25 years, and those don't really fit real well. So it's the outliers that will perhaps, it won't cause difficulties, but are going to have to take some real thought to figure it out. My point being in all this is most of the crimes will naturally just fall into a category. Again, unless we decide wholesale that certain categories of crimes really should have a different penalty than they currently have right now. So I think that the next steps are not as arduous perhaps, except, and again, I'll defer to Judge Treadwell to see if if that's correct. So I don't fear that this is going to necessarily collapse, but I still really believe that we should get this started, and particularly setting out the structure that we're going to be fitting things into, because that has now gone through the House and hopefully we'll get through the Senate, and has actually provided more guidance to the Sentencing Commission, because there have been some modifications to what the recommendation was. So that's going to further guide what we've done so far, will further guide the additional work that the Sentencing Commission is going to do. So there is that iterative process that's also involved in this. So I think that's another reason that this approach seems to be one that is working, or should be, should work. And hopefully some of the other witnesses can also weigh in, because I know that, for instance, I keep on saying Judge Treadwell, but he's been involved in this for getting close to probably a decade on this, and probably has some opinions on this view, on this particular issue.
Wow. Any other questions from the committee? Senator Benning. Looks like Senator Benning's enjoying himself out on a beautiful spring day.
Trying to. Martin, first I'll congratulate you for raising something that will no doubt end up as a bar association question on the bar exam for some poor students trying to figure out how this new scheme works. I recall these conversations from back in law school, though, with uniform attempts to try to get categories for all criminal acts and line them up with what other states were doing. I don't have any problem with the concept, but I'm going to agree with Philip that my initial hesitancy was, we have not just the Sentencing Commission, but Justice Reinvestment and other entities that are in play right now trying to figure out what should be criminal, what shouldn't be criminal. And I came away thinking that, are we putting the cart before the horse or not? You've done a pretty good job answering Philip's concern. I still have some hesitancy, but I just wanted to let you know I support the concept. I'm just trying to wrap my head around not it would be better to wait in what should be criminal, resolve those issues, and then we try to establish categories into which those leftover things we believe should be criminal fall into whatever categories that have been set up. I guess I'll leave it at that. It's more of a comment and not anything that would require some lengthy answer on your part.
How about a short, quick answer?
Sure.
Okay, so I mean, we had CSG, we had Ellen Whalen Weist testify, and also spoke with the Sentencing Commission, and it's kind of was following what we were doing and is supportive of that. And I would recommend, if you want to continue to look at this, to ask for her to either testify, and I've bounced issues off. They have an expert on these criminal codes. His name is Carl Reynolds. And I've been in touch with him over the last year on the Sentencing Commission work on this classification. And I believe from the input I got from them, they're very supportive of what we're trying to do with that and feel that it's consistent with what's happening with justice reinvestment. But you can ask those folks. So.
Any other questions? I have a couple, Representative Lamont. I guess the first one is, I was listening to a group of prosecutors trying to explain the charges against the 4 police officers in the Floyd case in Minneapolis. And they were all obviously Minnesota, but trying to explain the differences between aiding and abetting and all the other different charges that could be brought and what was being brought, and then getting into the details of it. And it made me curious as we do this, and particularly in the issue of attempts, which, as you know, during the Jack Sawyer case, there was a lot of discussion about the attempts law. And of course, they're charged there with aiding and abetting in a class, I want to get this right, second degree murder in the commission of a felony, which, so that, all of that. So when I was thinking of that and applying it here, what we're trying to do, would that get in the way, or would it help it? Or what's your opinion on that type of thing? I see you have attempts as your final thing on the bottom, that page 2 of the side by side that Eric did of the Sentencing Commission and the House bill. And I'm curious as to what happens with attempts under your scenario.
I'm trying to find that in the bill right now. And my understanding is we really haven't changed what the standards are or what needs to be proven for an attempt. We've only changed slightly as far as what the punishment would be for an attempt. And I seem to not be able to find, maybe I can defer to Eric on precisely what that is. It doesn't change the standard. Page 5 and 6, okay.
It doesn't change the standard?
Correct. It does not, although in different.
Does it change the sentence? I mean, would these, if this had happened in Vermont, hopefully it wouldn't, but if it had, would these 3 officers who stood by, did nothing when Mr. Floyd was telling them that he was going to die, that he couldn't breathe, would they then be charged with a lesser crime than the officer who had his knee on the man's neck? Under the change here that's contemplated in this bill.
That might be better answered by somebody who's more involved in the criminal justice system than me. I don't think, just looking at the language right now, I don't believe it really changes in the situation of a felony, an attempt in a felony situation.
Okay.
And that can be confirmed by, you know, Eric or one of the other witnesses.
One of the reasons that I support the effort, not sure I support the bill, but to support the effort, is the goal of having more uniform justice in the state. And we all know that in various counties, particularly amongst misdemeanors, one case may be diverted, never even charged. In another county, it would be charged. And in another county, it might even lead to jail time. So your $20 counterfeit bill that Mr. Floyd was accused of in some counties probably would have been diverted without even going to court. And you know, you just lead that on there. And so I think that's an important reason to move this forward, but I'm not sure that I agree with you that the bill itself will accomplish much other than saying, well, we're committed to doing it.
Well, I think that it does. I think when you look at the property crimes, even, you can see how we're trying to address the concept of geographic justice and disparities. That you know, as an example, if I can just run through an example of how this works, that, you know, if you have somebody who steals $200, if they steal it out of their employer's cash register, you know, that would be an embezzlement, and that's up to 10 years in prison. If they steal it, if somebody steals it out of not their employee's cash register, but, you know, the local gas station, you know, that would be petite larceny, and that's a 1-year prison sentence for $200. You know, if you write a check, you know, you steal your grandmother's checkbook and write a check for $200, that's uttering forgery. That's a 10 years in prison. But if you use her credit card, you know, that's fraudulent use, and that can be 1 year in prison. So you have these crimes that all involve a similar kind of action and similar damage, and you have quite disparate penalties, and this bill would take care of that. But also, you know, you may have an example where there's an embezzlement, and that's, you know, the average felony sentence for embezzlement right now is 3 years. You know, but in one court, it could be charged in a different county. It could be charged for up to 10 years. And we are narrowing or reducing the maximum sentence. So there's a less broad range of sentences that can happen throughout the state in different counties. And that's part of the way that this would, you know, narrow those disparities. So that's just a couple examples, and I'm sure some of the other witnesses can weigh in on why they think that this does help with that particular issue. And how we're dealing with the property crimes.
Thank you. Other questions for Representative Lamont? Hey, thanks so much for joining us, and
I appreciate it. I'll probably
hopefully
sit in
we'll
this.
hopefully see you in person one of these days.
I hope so. I'm getting tired of Zoom.
Between
even though
now
it
and
is
January.
handy. I was
I think
able,
Alice
yes.
has her hand up, but she's
Oh, I'm
muted.
sorry, Alice.
Senator Sears, there was one piece that we discussed in our committee, which was, you know, us seeming to go in the direction of more, well, what do we call it, versus some guidelines such as this imposes. We were going to move to more risk-based, which this
Right.
doesn't seem
Oh,
to do
good
that.
point. Yes.
So I'm wondering if that could be addressed.
So that was a question, I did get a heads up from Eric that was one of your, the questions you were interested in. And that's my latest communication with CSG is I reached out to CSG, to Ellen, and she forwarded my question to their expert. And there really are no criminal codes that this expert knows of that bases the penalty on the risk issue. And it's my understanding, and again, the other witnesses can certainly weigh in on this, is the issue of risk is taken into account by the court and also the prosecutor when determining what the sentence should be within the statutory allowed sentence. Risk is taken into account there, but not for setting what the maximum sentence might be for a particular offense. And this is something that, again, the CSG expert agreed with, that is the case. But again,
Well,
you can,
I would say that's a little taken out of the context that we're looking at.
okay,
When you look at the CSG study of the women at the correctional facility in South Burlington, for example, you found that there were a number of low-risk women with high category offenses who are incarcerated. And most of them are reincarcerated at the Chittenden facility on technical violations of furlough. So you have this situation where, because the charge is such that it was quite high, so you ended up with this range of sentencing. Then you go through the furlough process, and even though their risk to reoffend is low, the offense, not necessarily their risk to violate the conditions of the furlough, you end up with this large number of women incarcerated. And I don't have the figures in front of me, but you've had them in the report from CSG. So that's really what we were talking about. When you have this, you're correct that, and I think that she was answering based upon that, but we were responding based upon how the system functions, and how that system needs to adjust itself for the risk level of the offender.
right. And again, I don't think that goes to what the maximum penalty statutorily should be. We're certainly comparing offenses and, you know, the level of wrongdoing and culpability, et cetera, and and the damage done to determine what the maximum sentence is. But again, as far as the risk issue, it's where in that sentencing range that the judge and the prosecutor requests and the judge grants or not, they place the individual. And it's I think two very separate things. I do understand exactly what you're saying, that individuals are being incarcerated perhaps longer than they should be because they're low risk of reoffense. But I don't think you solve that in determining maximum sentences that are statutory.
Okay. Other questions? Thanks, Alice, for bringing that up. All right, why don't we move on to the next witness? And I'll tell you that New York's got its a very easy way to get tested for COVID as compared to Vermont. They use a mouth swab and don't use the nasal. So we were in and out of there in 5 minutes. It was unbelievably efficient in New York. So I would suggest you go to New York for the swab if you need it. Anyhow, Judge Grierson, we're meeting on H.580, not on cotton swabs.
Thank you. Thank you for the clarification.
Yeah.
For the record, Brian Grierson, Chief Superior Judge. I'm going to make my testimony very brief. Thank the committee for inviting me, but as Representative Lalonde has indicated, Judge Treadwell, who was on this witness list, is intimately familiar with the process, not only the present bill, the work of the Sentencing Commission, but also the history with the Sentencing Commission that I did not have. This clearly, as both Senator Sears and others have indicated, Senator Baruch, this is really a policy decision on the part of this committee and the legislature. And at least in the House side, Judge Zone testified as the chair of the Sentencing Commission, and I did not take a position one way or another on behalf of the judiciary. So I would defer in this matter to Judge Treadwell with his background and his position as the head of the subcommittee involved with this particular part of the Sentencing Commission. If anyone has questions, I'll be glad to answer them, but I think you want to hear from Judge Treadwell.
You're muted, Senator Sears.
Well, I have another phone call regarding adult day programs and
Mhm.
saving them. I'm sure you're all getting them.
Yeah.
And I was muting myself so you didn't have to hear the phone ringing in the background. Anyway, any other questions for Judge Grierson? Judge, thanks for joining us.
Thank you, and I may have to leave early, but I'm going to stay on as long as I can. But thank the committee for
Appreciate
inviting
that.
me.
I'm going to jump into the around the schedule a little bit and ask, since I can see him here, John Treadwell, who's been mentioned by our two previous witnesses as the expert. So if Judge Treadwell, and welcome back to Senate Judiciary, Judge Treadwell.
Good morning, Senators. It's very nice to appear in front of this committee again after I think it's been a couple of years. I'm not sure it's fair to classify me as the expert in this. I probably have longer experience with it, but I wouldn't call myself an expert. I was a member of the Act 6061 Criminal Code Reclassification Working Group that Representative Lalonde mentioned, along with Defender General Valerio, former State's Attorney Cahill, and Judge Morris, along with Robin Joy from the CRG. It was that group that came up with a proposal to take all existing Vermont crimes and classify them into 5 categories of felonies and 5 categories of misdemeanors. Ultimately, that work was referred to the Sentencing Commission, of which I am a member as Judge Grierson's designee, and a subcommittee of that group took a look at the report and has been coming up with proposals that have ultimately been presented to the legislature. Act H.580 flows directly from a couple of those proposals that were sent over. I don't know if it makes sense for me to go over what Representative Lalonde already covered. I think it was dealt with very clearly. I think I can probably provide a good example of why property crimes are included and why why the proposal is very different with respect to property crimes. Vermont's property crimes consist of numerous, often overlapping statutes with very disparate penalties that could be applied to particular conduct. A good example would be a person fraudulently using someone else's credit card to buy $20 worth of gas. That could be charged as credit card fraud, punishable by 6 months, a maximum of 6 months in prison or a $500 fine. Misdemeanor false pretenses with a maximum of 1 year and a $1,000 fine, or misdemeanor false personation with a maximum of 10 years and a $2,000 fine. And various prosecutors' offices may choose to charge that offense in various different ways. What this proposal here would do would be to say, if the amount taken was $20, the maximum penalty can be no more than 30 days and $500. The idea is to deal with one level of disparate charging by creating consistency based upon the amount potentially stolen or involved in the incident. The idea was to enhance transparency, to enhance consistency, and make it easier to understand the relative seriousness and proportionality of criminal offenses.